Imagine for a second that you're at home, just, minding your own business. It's a Tuesday night, maybe you're watching TV. A total stranger knocks on your door. He looks a little desperate, and he asks you where he can buy some illegal drugs. Now, you don't have any. You aren't a dealer. But you happen to know a guy a few blocks away who is.
It creates an immediate moral dilemma, doesn't it? Do you slam the door in his face, or do you try to get this guy off your porch by giving him what he wants?
Right. So in this scenario, trying to be helpful, or maybe just trying to make him leave, you draw him a little map. You sketch out the streets, put an X on a house a few blocks away, and say, go there. The stranger takes your map, walks to that house, and successfully buys drugs. Here's the question we're answering today. Did you just commit a crime? And specifically, did you commit the crime of selling drugs?
Most people would say, no way. Common sense says you gave directions, you didn't touch the drugs, you didn't touch the money, you didn't profit. But the law is a lot stickier and, frankly, a lot more dangerous than common sense.
That is exactly what we are unpacking today on this deep dive. We're looking at a landmark criminal law case from the Supreme Court of Washington, State v. Gladstone. It's a case that forces us to draw a line in the sand between mere communication, just sharing information, and actual criminal participation.
It really is the definitive case on what lawyers call accomplice liability, or aiding and abetting. To understand why a map might or might not send you to prison, we have to dissect a very specific legal requirement called the nexus.
The nexus. It sounds like something out of a sci-fi movie.
It does sound dramatic, but in a courtroom, it's the difference between being a bystander and being a felon. We're going to look at how the court used a standard set by one of the most famous judges in American history, Learned Hand, to figure out what it truly means to abet a crime.
Okay, before we get to the map-drawing marijuana case, we need to set the ground rules, because this feels counterintuitive. If I'm not the one physically handing over the drugs or taking the cash, how can the government charge me as if I did? What's the general rule here?
The general rule comes from a statute, but it's really rooted in centuries of common law. Basically, the law says that there is no distinction between the person who actually commits the crime and the person who helps them do it. If you aid and abet, you are a principal. You're just as guilty as the guy holding the bag.
So, legally speaking, the helper and the doer are the same person.
Exactly. If you help a bank robber, you are a bank robber in the eyes of the law. The theory is that without your help, the crime might not have happened, so you share the liability.
But surely there's a limit. I mean, if I hold the door open for a guy who happens to be a bank robber, am I a criminal? Do I have to know he's robbing it?
That is the million-dollar question. And the courts have adopted a three-part test specifically to stop the government from sweeping up innocent or at least semi-innocent bystanders. It comes from a famous federal case called United States v. Peony.
Peony. Okay, what did the Peony case decide?
Well, Judge Learned Hand wrote the opinion. He's a legend in legal circles, known for his really precise use of language. He wrote that to be an aider and abetter, it's not enough to just be present or knowledgeable. You have to do three things. First, you have to associate yourself with the venture.
Okay.
Second, you must participate in it, as in something you wish to bring about. And third, you must seek by your action to make it succeed.
Associate, participate, seek to make succeed. That sounds like you need to be pretty emotionally invested in the crime.
You do. It implies what the law calls a purposive attitude.
Yeah.
You can't just be indifferent. You have to want the crime to happen. You have to have a stake in the outcome.
That distinction between knowing it will happen and wanting it to happen seems simplistic, but I suspect it's going to be crucial here.
It's the hinge the whole case turns on.
All right, let's bring in our case, State v. Gladstone. We're going to do this rigorously today. We want to walk through this just like a court would, stripping it down to the studs using a structured analysis. So let's analyze State v. Gladstone. First, what are the legally dispositive facts?
Okay, here's the scenario. You have a man named Douglas MacArthur Thompson. He's a student, roughly 20 years old, but he's also working as an agent for the police.
An undercover student. Got it.
Right. So Thompson goes to the apartment of the defendant, Bruce Gladstone. It's late, maybe 9 p.m. Thompson knocks on the door and asks Gladstone to sell him some marijuana.
And what does Gladstone do? Does he sell it?
No, Gladstone refuses. He tells Thompson he doesn't have enough on hand to sell. But, and here's the fatal moment, he tells Thompson that he knows a guy named Robert Kent who has plenty and would be willing to sell.
He redirects the customer. I'm out, but go see Kent.
Precisely. Gladstone gives Thompson oral directions to Kent's place. Thompson wants to be sure he can find it, so he asks for a map. Gladstone grabs a pencil and paper and sketches a crude map about 8 lines showing where Kent lives.
Okay, so Gladstone provides the intel. What happens next?
Thompson takes the map, leaves Gladstone's apartment, and goes straight to Kent's house. He follows the directions, finds Kent, and buys 8 ounces of marijuana. The police, who were waiting nearby, eventually arrest Kent, but then they circle back and charge Gladstone.
But wait, Gladstone didn't sell anything to Thompson? He just drew a picture.
Correct. And this is where the charge matters. They charged Gladstone with aiding and abetting Kent in the sale of marijuana.
Okay, there's one fact I need to clarify before we move on because it seems like it would make or break the case. Did Gladstone call Kent? Did he tell him, hey, I'm sending a guy over?
That is the single most important fact in this entire case. No. There was absolutely no evidence of any prior agreement. No phone call, no text message. Well, it was 1970, so, no telegrams. There was no communication whatsoever between Gladstone, the map drawer, and Kent, the seller. They didn't even prove that Kent knew Gladstone sent him, at least not based on any prior arrangement.
So Gladstone is sending a customer to a business partner who doesn't even know they're partners.
Exactly. Keep that in mind.
Okay, those are the facts. So what was the core legal issue?
The issue is this. Does a defendant aid and abet the sale of marijuana by merely directing a purchaser to a seller and drawing a map when there is no nexus, no connection or communication between the defendant and the seller?
It feels like he definitely aided the purchase. I mean, without Gladstone, Thompson never finds the weed.
You nailed it. He aided the purchase, but he was charged with aiding the sale.
That seems like such a semantic distinction. Buying and selling are two sides of the same coin.
In economics, yes. In criminal law, they are different universes.
All right, let's apply the rule. We have the Peony test associate, participate, seek to succeed, and we have this concept of the nexus. What rule of law did the court apply here? Could you state the full black-letter rule and break it down into its testable elements?
Of course. The court applied the common law rule of aiding and abetting, but interpreted through that Peony standard. The rule really has 3 distinct elements regarding the relationship and intent. First, there must be a nexus between the accused and the principal, in this case, the seller.
Okay.
Second, there must be a purposive attitude, those 3 Peony steps: associate, participate, and seek to make succeed. And third, there must be an absence of mere bystander status, which means mere knowledge that a crime might occur is not enough.
Thank you. Okay, now for the court's elemental analysis. Let's walk through this step by step.
Yeah.
How did the court apply that first element, the nexus?
This was the fatal flaw for the prosecution. The sub-issue here was whether Gladstone had any connection to the person committing the crime he was charged with aiding, which was Kent, the seller. The rule requires a link between the aider and the perpetrator. The court looked at the facts and found the nexus explicitly missing. Gladstone communicated with Thompson, the purchaser.
Right.
He gave the map to the buyer. He never spoke to the seller.
So because he helped the wrong guy in the transaction, the element fails.
Precisely. The court held that without a link to Kent, he cannot be aiding Kent's crime. He might have been aiding Thompson's purchase, but again, he wasn't charged with that. The court said that to aid a specific person, you have to be in league with that person.
That feels incredibly technical. I helped the crime happen, but oops, I helped the wrong participant.
It is technical, but it protects a vital principle. You can't be an accomplice to someone you don't even have a relationship with.
Understood. Now what about the second element, that purposive attitude, the wish to bring about the crime?
This is the Peony test application. Did Gladstone participate in it, as in something he wishes to bring about? The court analyzed the evidence to see if Gladstone got anything out of this. Did he get a kickback, a finder's fee, even a thank you from Kent? Nothing. The court found no evidence that Gladstone derived any benefit, any reward, or any consideration from the sale.
He did it for free.
He did. And because he had no stake in the outcome, the court said he couldn't be said to be seeking by his action to make it succeed. In the eyes of the court, he was just indifferent. If Thompson got lost, or if Kent refused to sell, Gladstone didn't lose anything.
So mere helpfulness isn't enough to prove you want the crime to succeed.
Correct. The holding on this element was that it was not met. Drawing a map doesn't prove he counseled, encouraged, hired, or commanded Kent to sell. It just proved he knew Kent might sell.
Which brings us to the third element, the bystander distinction, particularly about the communication of information. This touches on speech, doesn't it?
It does, yeah. The prosecution argued that by telling Thompson where the weed was, Gladstone was verbally aiding the crime. The court cited another case, State v. Hinckley, to analyze the word abet. They said abet implies a consciousness of guilt.
What does that mean in practice with the information he shared?
It means that simply stating that another person probably will commit a crime is not the same as helping them do it. The court ruled it would be a dangerous precedent to punish someone for simply stating where a crime might legally or illegally occur.
I see. So if I tell you the bank is on 5th Street and you go rob it, I gave you information that helped you, but I didn't abet the robbery.
Exactly. Establishing the location of a potential crime isn't the same as joining the criminal enterprise.
And after analyzing all the elements, what was the court's final conclusion?
The conviction was reversed as a matter of law. The court ordered the case dismissed. Gladstone is not guilty of aiding and abetting the sale.
Wow. So he draws the map, sends the guy, the deal goes down, and he walks free because he didn't call ahead.
Essentially, yes, because he didn't have that nexus with the seller.
I have to play devil's advocate here. It feels like the court is bending over backwards to say he didn't help. If I'm a listener, I'm thinking, come on, he sent a cop to a drug dealer. Was there really no evidence connecting them?
You're sensing exactly what the dissenting judge, Justice Hamilton, felt. He wrote a scorching dissent. He argued that the majority was stepping into the jury box and ignoring the obvious.
What did the dissent see that the majority missed?
Justice Hamilton focused on what happened when Thompson arrived at Kent's house. Remember, Thompson is a stranger. It's late at night. He knocks on a drug dealer's door. That's a suspicious situation.
A good way to get shot, usually, or at least turned away.
Right. But Thompson testified that he used a specific phrase to get in. He said, "Gladstone sent me."
The password.
Exactly. And it worked. That phrase gained him immediate entry and resulted in a sale. Justice Hamilton argued that this fact alone suggests a community of purpose. It implies that there was a pre-existing arrangement, or at least an understanding that Gladstone could send customers to Kent.
That does change the flavor of it. If Gladstone sent me is the key to the door, then Gladstone is definitely part of the operation.
The dissent argued that the jury was entitled to infer that nexus. By overturning the verdict, the majority effectively said that even if Gladstone sent me worked, it wasn't enough proof of a prior agreement without more direct evidence.
That is a razor-thin margin. The majority is saying, well, maybe Ken just likes Gladstone, or maybe he just trusts anyone who drops a name.
Right. The majority wasn't willing to let a man go to prison on an inference. They wanted proof of the bond between the two men.
This concept of nexus is slippery. I want to make sure our listeners really grasp it because it feels like a loophole. Can we break this down with a hypothetical? Move away from drugs for a second?
Absolutely. Let's go back to the bank robbery. It's the classic law school example.
Okay, set the scene.
Scenario 1, the Gladstone scenario. You're walking down the street. A guy in a mask runs up to you looking frantic and yells, "Where is the First National Bank?" You're scared, or maybe just helpful, so you point down the street and say, 2 blocks left. The guy runs there and robs the bank.
I helped him find the bank.
Yeah.
Without me, maybe he gets lost and gives up.
True, but under Gladstone, you are not guilty of aiding and abetting the robbery.
Why?
Because you helped the robber, the person, find a location. But you did not participate in the robbery, the crime. You have no nexus to the crime itself. You don't care if he succeeds or fails. You just answered a question. You lack that purposive attitude.
Okay, scenario 2.
Scenario 2, the accomplice scenario. You're walking down the street. You see the guy in the mask running toward the bank. You realize he's going to rob it. You run ahead of him and hold the heavy glass door open so he can run in faster and get the jump on the guards.
I'm just being polite, holding the door.
In this case, that politeness gets you 20 years.
Why is holding the door different from pointing the way?
Because holding the door is an affirmative act to facilitate the crime itself, not just giving info to the person. By holding the door, you have associated yourself with the venture. You are taking a physical step to ensure the robbery succeeds. You've joined the team.
So the distinction is helping a person who happens to be a criminal versus helping the crime itself happen.
That is the key distinction. Information versus participation.
This is tricky stuff. If I'm a law student listening to this, or just someone trying not to accidentally commit a felony, how do I keep this straight? Can you synthesize this into a checklist? A deep dive diagnostic, if you will.
I can. If you're looking at a fact pattern to see if someone is an accomplice, use this exam framework. It has 4 steps.
Step 1.
Check the charge. This is where most people trip up. Who is the principal and what is the specific crime? In Gladstone, the crime was selling. Gladstone helped the buyer. Since he wasn't charged with aiding the buying, the case falls apart right there. Always check whose team the defendant is on.
Step 2.
The nexus test. Is there a connection between the defendant and the principal? Did they talk? Did they plan? Did they high-five? If there's no communication between the helper and the doer, you probably don't have aiding and abetting.
Step 3.
The peony trio. This is the deep analysis. Did they associate? Did they participate? Did they act to make it succeed? You need affirmative steps towards success, not just passive knowledge.
And step 4.
The intent check. Does the defendant have a purposive attitude? Or just knowledge? Remember, knowledge is not intent. Knowing a crime will happen is being a bystander. Intending for it to happen is being an accomplice.
That final takeaway is crucial. Knowledge is not intent.
Right. And practically speaking, the rule from Gladstone is this. If you help the buyer find drugs, you generally cannot be convicted of aiding the seller unless you have a specific agreement with that seller. You're on the wrong side of the transaction to be his accomplice.
This has been a fascinating look at how the law parses intent. It's surprising, really. You can draw a map to a crime scene, you can send a guy right to the source, but if you don't know the criminal acting there, you might be off the hook.
It protects the concept of individual responsibility. We don't want to punish people for words unless those words are tied to a specific criminal intent shared with the perpetrator.
But I can't stop thinking about that dissent Gladstone sent me. It worked like a charm. If the majority ignored that, did they let a guilty man go just to protect a legal principle? Or is protecting that principle worth letting a few Gladstones slip through the cracks? That's something for you to think about. Thanks for listening to The Deep Dive.
See you next time.